Welcome to Divorce Dialogues. I'm Catherine Miller. Divorce Dialogues brings expert guests to the airwaves to talk through your divorce questions and fill in the gray areas about separating. From thinking about divorce to how to behave during divorce to what to do after, this is Divorce Dialogue. Welcome to Divorce Dialogues. I'm Catherine Miller. I'm the founder of the Miller Law Group and a trainer at the Center for Understanding in Conflict, and I am on a mission to change how people divorce and help them divorce with dignity. And my guest today is Tammy Fried. She's a seasoned attorney with over 25 years of experience in tax, trust, and estates, and she's been advising individuals, families, and nonprofits on complex financial and legal matters. She's a founding partner of Radic Freed PLLC, and she brings a thoughtful, strategic approach to helping clients preserve wealth, plan for the future, and navigate major life transitions, including, of course, divorce. Welcome, Tammy Fried. It's a pleasure to have you on the show.
Thank you so much, Catherine.
I know that you've worked with all kinds of people, from young couples just starting out and starting their families to high net worth individuals later on in their career. And I'm wondering, in thinking about all those different life stages, how do estate planning needs shift across the life stages, especially after divorce?
Sure, that's a great question. So, look, every situation is different. Speaking generally, when you're a young couple, you have few assets, you're still in the building stage. So, your main concern is taking care of your children and what would happen to them and preparing for the future. If one of you were to pass away, both of you were to pass away, who would be named their guardian, who's going to be making the financial decisions, how to provide for your children, how to pass along the assets. And then as people go through their lives, wealth is accumulated. So again, this is generally speaking, you're thinking of how to pass along those assets to the next generation. And then you're also speaking as you're getting older, who's going to help make decisions for me if I'm incapacitated in the later stages of your life. When we're talking about someone post-divorce, we're anywhere along that spectrum. So these are the same questions that are coming up, but now there's no spouse involved. You're talking as a single person, but you may have kids. You may be earlier in your life or later in your life. But as an estate planner, you have a relationship with your client. You need to know where they are on that, we're calling it a spectrum, but where do the kids fit in? What are the assets involved? You need to know all those aspects and you help plan them accordingly. We meet you where you are. So where are the kids? Who's going to help make those decisions, whatever those decisions are for you when you are no longer here. Are you the early stages? Or are you the late stages? So, it's like an extra wrinkle when you're, in a divorce, but in the same way, if you're single, you don't have the spouse, the partner, what have you.
You mentioned, Tammy Fried, the guardianship, right? And of course, a
Sure.
guardian is someone you name to physically care for your children should you pass away while they're still in need of care. And, I guess that it's less likely that parents will die together once they're divorced, but it's also, I think some of my clients really struggle with this question: who should be the guardian of our children? Do we name the same guardian or not? And I wonder how you advise your clients about choosing that guardian and whether or not to coordinate that.
So that's an really interesting question. It comes up even frankly with couples, and that ends up being a lot of the stumbling block and where people get hung up on because it ends up being, well, I don't really like your brother and I don't really love your sister. And then you
Exactly.
go dormant and you don't hear from the couple. And it might get exacerbated in situations where I'm the divorce. So I would, when it is a divorced couple, the fact is we don't, if one spouse, ex-spouse passes away, it goes to the other living parents. To the extent there are issues with, if a parent didn't think that the other parent was fit, like that's a family law issue. So we can't change guardianship if
Or
there's a parent involved. That's not us. I would recommend, to the extent a couple is still together or apart, if you want, consistency. But you're right, it's unlikely that, especially when the parents are no longer together, that they're not going to pass away at the same time. So it can be up to whomever is the last to die, who is going to be the deciding factor of where it is. But it should be ultimately both parents want the best for their children, of course. So they're going to be naming people who will take the best care for their kids. And you hope that's going to be the case. And, as you get to know the clients, you have these conversations and, you're getting to know them and you're hoping that they're taking care of their children. But it does go to the other parent who is still living. So,
Course. That's what I was saying that,
yeah,
I think it becomes less likely. But, I've had clients who became the guardians of their friends' children when the parents passed away, still married, but passed away at separate times. So it does happen. And asking someone to take on guardianship of your children is a big ask. Let's make no
no,
mistake about that.
yeah, we do advise co- parents, or whether they're together, whether they're apart, to let the people know who they have in mind, to give them a heads up, because like you said, it is a big ask. Even if they're there to take on the financial responsibility of being a trustee of a trust that has the assets, whether or not they're going to be the physical guardian of the kids, because you're being asked to make financial decisions as to whether expenses with respect to the children are the appropriate expenses. So, and then you have to go back like, oh, is this something that, my friend would have wanted for their children? And yes, it's remote that people are going to pass away, and at what point in someone's life, but of course, we all know it does happen. Like, things happen in life, and unfortunately, kids lose their parents before they are of, maturity age. So you want to be
Yeah.
prepared. I mean, that's where estate planners come in.
So Tammy, if we let's move to the cheerier topic of divorce from death. Although certainly these are topics that you as an estate planner talk about every day. And a lot of divorcing people feel really overwhelmed by the financial restructuring that happens in the divorce itself. And one of the things that I say to our clients is, listen, this travels all the way through to your estate plan, right? That the financial restructuring has this sort of tail end to it, and it's not really done until you really think about that. So what should those people who are restructuring their financial lives think about when it comes to rethinking their estate plan post-divorce?
Catherine, you're so right, but really the hard work has been done when they've finished with you. I mean, with they've done all the hard work, and the effort and the sweat and the tears has been on, like, splitting up the assets. Once that's done, in terms of the estate, it's really about like you said, it's carrying through that tail end of, okay, where are you planning, for that next stage when you're no longer here, to the extent they have children. Now you're dealing with, okay, this is your pot, this is what's left. How are you planning to say, where is it going? How are you going to care for yourself, care for your children? To the extent they haven't dealt with any financial decisions before, this is when you say, okay, now's the time to educate yourself, and that's fine, but maybe talk to a financial planner or start researching yourself. Take some time, you know, do some education. Certainly, now is the time, like you said, to go over your retirement plans and go to your financial institutions and make sure the beneficiaries and your TOD, your transfer on death documents, are up to date and appropriate. Make sure, the documents that you have, your power of attorney, it's the right individuals are listed there. If you have a great post-divorce and your ex-spouse is the person that you do trust and you want them to be your power of attorney, great. Then, to the extent you have a power of attorney and it lists your ex-spouse, you're fine. But most people,
That's not most people.
not most people, that's the time that you update them because, and certainly the beneficiaries, like people forget that first job that they had right out of college. They had a plan and they put $1,000 into a retirement plan. Well, you know what? In 40 years, that can grow to 500,000. And they might have listed it, a spouse, but they might have listed a boyfriend or a girlfriend. There's just a story into 2024 where this gentleman worked at Procter and Gamble. Everyone can look it up. He listed an ex-girlfriend. They broke up and he never got married. She went on to get married. 40 years later, he forgot about it. He passed away. It grew to $1 million. And it likely will go to this ex-girlfriend and not his brother. And there's nothing you can do because it trumps the will and it trumps the laws because it's a transfer on death. Whatever he wrote is what trumps everything. So change those documents. Like the first thing you do, go change the documents, update those. And then, of course, update your will or create a will and make sure the people in your life who are currently in your life are the ones you want to take care of and where your assets want to go. Let's just follow through and get to that finish line.
I'm Catherine Miller, and you're listening to Divorce Dialogues, a podcast dedicated to educating people about divorce related topics so everyone can divorce with dignity. Subscribe to the podcast wherever you listen to podcasts to be sure that you don't miss an episode. And I'm talking today with Tammy Fried about the intersection of divorce and estate planning. And, so Tammy, for people who are wondering, what documents are changed by divorce and what aren't, right? Like if you do you have to redo your will? Like I know that in New York that if somebody has a will that says, as many people's do, everything to my spouse and then to my kids, if they get divorced, then it's as if their spouse died before them, right? And then everything would just go to their kids. But some of these documents that you're talking about, a transfer on death documents that pass outside the will or life insurance policies, what is it that people really need to pay attention to when they get divorced to be sure that something like what you're just describing doesn't happen to them?
Right. So I would advise make a list of every bank account you have, every stock and security account, every account
Let me
you have.
just say that as part of the divorce, you would have already done that. So you could just
Correct.
take the
You
list right.
have all this homework done. This has
Yes.
been like all the effort that you've done, and it's terrible and it's awful, but you have these lists. So piggyback on all the work that you've done and go through and make sure to the extent you have, when we say transfer on death or TOD, these are these forms that you can fill out at a financial institution that bypass your will. So it's a one pager usually, and it allows you to list a beneficiary. So you could have listed your parents or your husband or wife or your best friend or whomever, children. And that form that you've signed at any point in your life will bypass your will, bypass your trust, and the bank or financial institution, whichever, has to follow it. So if you haven't changed it, regardless of the fact that you've changed your will, the bank has to follow it. So that's like the first thing to do is make sure all of those are up to date and like get that done. And that's a quick one. Call the bank, they could do it. I think you can probably do it online now in most cases everywhere. And if you don't want to do it like that, just make the phone calls and, send in the documents. And then, the documents that are general, it's the will, you update your will, you update or your trust, whichever one you have. So the will, you can either have a will or a trust plan. Then there are what we call the ancillary documents. So these are documents that you have that go along with your will or a trust, and it's part of your whole estate plan. So it's a power of attorney, which is the document that allows someone trusted to make financial decisions on your behalf if you are incapacitated. Then there's your healthcare proxy, which is that same concept for healthcare decisions. If you're incapacitated, it's someone whom you trust can make these healthcare decisions with your doctor. And then there's the living will, which are, the instructions that you may have at for end of life decisions that you can memorialize and have written down. So, it's additional information for your doctor or any of the doctors that you have when those decisions have to be made at the end of your life. This is not when, there's a chance of you being resuscitated. This is at the end of your life, what you want to have, being medicated, TNR, all those decisions. So those are the ancillary documents.
That's great. I think that one thing that people don't necessarily realize when they get divorced is that they're losing some estate tax advantages. And I'm wondering what you think. And I also think that at the time that we are recording this episode of Divorce Dialogues, the lifetime exemption is very, very, very high and really doesn't impact a lot of people. But there's chat, about it being lowered as part of a deficit reduction plan. And if that happens, then maybe this idea of having to think about tax planning is relevant for more people. And I'm wondering if there are some opportunities for charitable giving or something like that might help substitute for some of the tax advantages of being married when you die.
So, there's always talk about the estate tax regime maybe going away. It depends if there's Republicans in office or Democrats in office right now. It's about 14 million. It's actually supposed to sunset in 2020, at the end of 2025. It may not. It may stay up at 14 million. And to sunset, it will be, back to 7 million, give or take. So in New York, though, there is a state estate tax, which is also at 7 million. So there's that to keep in mind. There are things that can be done with the use of trusts that people do. You can do charitable giving as well because, those are tax free. I think this is sort of beyond the scope of what I was thinking with respect to divorce, but these are things that you can talk to your tax lawyer or estate tax lawyer. Off the top of my head, one of the things that we do for clients is create trusts for kids or grandkids to put lifetime, sorry, not lifetime, the annual tax exemption, gift tax exemption. So giving annually, you can give about 18,000 per child. You can give, or per child, per anyone, you can give a gift tax, 18,000 tax free. It's this year. So you can just keep giving to a trust each year and that can accumulate. So these are things that you can do. I mean, people give crats and cruts. So there are, a whole host of different things that people do. One of the things actually I like in terms of giving charitable donations, this is a little bit also beyond the scope, is I find it annoying sometimes to give, you give to various different charities, and then when it comes to time for tax time, you have to find all the receipts that you have, and you're like looking in your emails and then you're looking in your mail and it's like this receipt and that receipt. But if you give to a donor advised, the use of donor advised funds comes in very handy because you can give to a donor advised fund like one lump sum, and that is the receipt that you need. And then with the donor advised fund, you can use that to make ongoing contributions to other charities. So it's, using that one giving opportunity to give the donor advised funds. That's not like a benefit in terms of reducing taxes, but that's just a way to reduce administrative work.
Yeah.
So
That could really be a real pain in the neck to
looking
try to
for
come
those
up with all of
receipts.
those
Yeah,
receipts.
the
So
administrative.
you've been mentioning trust, so let's talk a little bit about trusts. For somebody who is rethinking their estate plan post-divorce, and they're thinking about protecting their kids, and a lot of people are doing that. What are some trust strategies that they could employ to make sure their kids are actually protected?
So we like to leave assets to kids in trust, certainly when kids are below the age of majority, it's automatically going in trust because, that's really the law. They don't have the ability to make well, they may have the ability to make sound decisions, but the law does not afford them that ability. So it goes in trust and there's a trustee appointed. But even when a child is older, we often do recommend that you don't give the children outright their assets, but that it goes into trust. And the real benefit there is that it would be protected in the event of their divorce. It doesn't become a marital asset. They would be, depending on their age, you can allow them to be their own trustee of their own trust, and there are certain rules that they would have to follow. And they could be educated, they could be a co-trustee, and then as they learn about being a trustee, they could be their own trustee. But, there's asset protection there. And what's really nice is if they, it's protected from their own divorce, it's protected from lawsuits or anything like that. So leaving assets in trust is a really nice ability to protect it for the next generation.
You're listening to the Divorce Dialogues podcast, and I'm Catherine Miller. Divorce Dialogues has been educating people about divorce and relationship issues for over 10 years. Subscribe to the podcast wherever you listen to podcasts, and don't forget to check out our previous episodes on the podcast website, divorcedialogues.com. And I'm talking today with Tammy Fried about the intersection between divorce and estate planning. So, Tammy, if people want to find out more about you and your practice, how can they do that?
Sure. So my partner and I have a firm. It's Radic Freed PLLC, like you mentioned, and our website is radicfreed.com. So it's RADDOCKFRIED.com.
And Tammy's contact information will be in the show notes wherever you're listening to this. So, one thing that I think Tammy Fried is really kind of interesting is sometimes in the divorce process, people say, I want to ensure that you, my soon-to-be ex-spouse, will leave a percentage of our estate to the children. And I'm going to agree to do the same thing. And of course, there are concerns about doing that in the event that somebody remarries because you're really binding someone else. So this is sort of like off notes, but what are your thoughts about kind of combining those two ideas of estate planning into the settlement agreement itself?
I definitely think that should be that definitely should be an agreement. Yeah. If you want them to leave it to, I mean, you would hope that each spouse has the best interest of those children, but you always hear these horror stories of, children got forgotten. To be honest, it comes up often in the case of a spouse passes away, not even in the case of divorce, but a spouse passes away and then the spouse gets remarried, the living spouse
The
gets
surviving spouse, yeah.
remarried, the surviving spouse gets remarried, and to someone younger, someone who didn't have the best interests at heart, or even just mistakes were made. So we actually do build into our estate planning documents certain types of trusts and a Q-tip trust where the second spouse, the marrying in the new spouse, is not entitled to the corpus of the assets. They're entitled to income. And that corpus of the assets are protected for the children of the first marriage and other types of things, or they're not even, allowed to get married, or that the actual, the surviving spouse may forfeit some of the assets if they don't get a prenup before they get married. You can put in as stringent as you want, and that's all decided when the couple who are coming to us to prepare the estate documents so that they get replicated in the husband and in the wife or the two partners in both their documents. So it's an even, kind of situation. Both partners have both those provisions in their documents. But it can happen in any type of situation where, kids somehow get knocked out of their rightful ownership of shares, and certainly can happen in divorce as well. But yes, you want to protect the kids.
Absolutely. So, sometimes when people get divorced, they're left with a chunk of change, right? Post-divorce, but they weren't the person who was primarily making financial decisions during the marriage. And that person may have a lot of indecision or insecurity around making the money decisions. And in the process of estate planning, how do you help someone who's really insecure in that way or unsure of what to do to actually make those decisions?
So, a lot of times we do recommend that they get a financial planner because be, we're not going to advise on how to invest or what plan to do. And it's not uncommon that people don't have. And, there are times when the client comes in and, they're apologizing, and we're like, there's no apology. Like, it's natural to not duplicate efforts. And honestly, it's not rocket science. It's just you were busy doing something else or you chose not to do it. That's okay. But now find an expert who can help you. And we do recommend like get references and recommendations from friends, from trusted relatives, from trusted people, and interview financial advisors or get a book and do some research on your own, like take ownership of it. And yeah, it's hard. You've just been through this whirlwind experience of divorce. The rug's been pulled out from under you in the sense that what you thought your path was is not your path anymore. You are on a different path. Okay, take a second, but own it, and you can get through it, and you can learn because we can all learn how to figure out what to do with our money or just understand when people talk to us about it. But we do recommend to start off, depending obviously on how much they have. It's a good idea to talk to a financial planner and to find someone who you're comfortable with to get a sense of what to do with your money. And we can certainly, give them ideas or direct them in certain places
Sure.
to get a sense of, where to go. I mean, certainly your field also, like you run across people who that people would feel comfortable and that, would have a good relationship with them. But it's not uncommon. This is if you never, whatever, used a wrench, doesn't mean you can't, just means you haven't.
Yeah, exactly. So, just to wrap up in our last minute or two, if someone's listening to this and they haven't updated their estate plan since they got divorced, what's the first thing they should do? What should they do today to get started thinking about that?
Because, like you said, they know all their assets. Go and make sure that their transfer and death documents or their beneficiary, however it's called in their particular financial institution, that it's up to date and accurate what they want. Then go to their documents if they have them and take a look and make sure it reflects what they want. And if they don't have these documents, get them done. Get a will, or a trust document, get a power of attorney and healthcare proxy, figure out, and work with an estate planner. Like, I mean, and it takes some time, but this is not hard to do. You're not the one that's drafting it, and there's no, negotiation with the other side. It's really what you want to do. Like you are in the driver's seat now. There is no other person. There's something freeing about you can decide what you want your assets to go to. You can choose what charity. There's no, you don't have to listen to someone else now telling you, no, 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 I want it to go here. So, right?
That's
It's
true. You're totally, I mean, daunting as that might be, you
totally
are, right? You are making these decisions for yourself. So you don't have to argue about whether or not you want money to go to one person's college or your college or,
right. And also take a second, but don't take a second to look at the beneficiary list. Like that one, do now.
get that done today.
Yeah.
Well, Tammy Fried, thank you so much for being my guest on Divorce Dialogues. This has been super helpful for divorcing people thinking about their estate plans.
Thank you, Catherine.